Yesterday we were told a 5-4 decision which showed that the court is political. Today we have a 5-4 decision, and the court is magnificent. The genius that is the Supreme Court, 5-4 vote. Unbelievable. Now, I want to remind you of a couple things. First of all, the Chief Justice, John Roberts, the Chief Justice and his fellow justices wanted to hear, in specific, 4 issues at oral argument. They wanted 4 issues briefed by the various parties. 4 issues. The individual mandate, the Anti-Injunction Act, and severability, and Medicaid. Oops, they forgot to ask for a brief on the tax issues. And they didn't even really argue it during all those hours of unprecedented days of oral argument. My goodness, what happened? What happened, Chief? Kind of a last-minute decision, huh? Well, Landmark Legal, we did brief this issue. And we were among the only parties to brief this issue. And we briefed it more thoroughly than the government. That would be the Obama administration. And you can go on our brief at landmarklegal.org and you can see it. And we say the individual mandate's penalty provision, that's what it's called, a penalty provision. Henceforth, the court has said it'll be a tax provision. Why? Because they say so. It cannot be justified as a permissible tax under any constitutional test, we explained. Arguments proffered by the federal government that this provision constitutes a permissible exercise of Congress's taxation authority fell under all established precedents and should be rejected by the court. All established Supreme Court precedents. Had Congress determined the penalty provision constituted a tax, it would have labeled it a tax, and statements by members of Congress and Obama made concurrently with its passage would have reflected as much. You see, ladies and gentlemen, Congress knows how to pass tax statutes. It knows how to pass tax language. It does it all the time. And here, I guess they just forgot. The federal government's latest brief concedes the point without realizing it, referring repeatedly to Section 5000A as a penalty. Yet even if this court assumes that Section 5000A is a tax, it still fails to satisfy the constitutional restrictions on taxes set forth in Article 1, Section 9, Clause 4. That's prohibition on the issuance of capitation or direct taxes, unless apportioned among the states, the 16th Amendment, the income tax, and the limitations set forth by this court as applicable to other Article 1, Section 8 taxes, such as excise taxes. Well, gee willikers, how did the Chief Justice get around that? Well, like a good activist, he just blew it off. He said it functions as a tax. Hell, just because it doesn't fall under any of the enumerated taxes in the federal Constitution, just because Congress didn't mention it, just because Obama specifically rejected it, doesn't mean it doesn't function as a tax. And look, you conservatives, look George Will, look Charles Krauthammer, look others. I'm going to save Obamacare, but I won't do it under the Commerce Clause. Don't I deserve credit for that? Oh. Now, a couple of things. The Anti-Injunction Act. First, Roberts writes that the Anti-Injunction Act, which prohibits legal challenges of taxing measures until a taxpayer has first paid a tax, got that? In other words, you don't have standing, the case isn't ripe until the tax is actually instituted, and then you want to challenge the tax. He said that doesn't apply in this case. You want to know why? You ready for this one? Please don't burp up your dinner. Listen to this. Because Roberts said the individual mandate is not a tax for purposes of the Anti-Injunction Act because Congress didn't call it a tax. Wow! So under the Anti-Injunction Act, which says essentially, look, you can't challenge a tax until it's actually instituted, and then it's instituted against you as a citizen or an organization, and then you can challenge. So wait a minute, Congress didn't say this was a tax. Now I'm confused. So it's not a tax for the purposes of the Anti-Injunction Act, but it is a tax for the purposes of the individual mandate. Confused? Well, so the hell is everybody else, because it doesn't make any sense. But I shouldn't be so rude, should I? He's the Chief Justice. Oh, yes, I knew him way back when he served in the Reagan administration. Now, when we come back, I'm going to hit the other aspects of this decision, which are also so profoundly stupid. I'll be right back.